Okay, real quick, Doug from Salt Lake. I said this last time in the middle of my video. I'm going to say it in the beginning this time. If there is no contract, there's no duty. Okay? If there's no contract for their services, there is no case. And they're just presuming and they're assuming, and you must rebut everything that they say and do. First thing you should say when you walk into that courtroom, fake-ass courtroom, kangaroo court, in front of that clerk, is say, show me the contract, or dismiss this case. Okay? And disclaimer, this isn't legal advice, not a lawyer, this isn't a law firm, blah, 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 all that bullshit. This is for education only. No contract, no duty, no proof of claim, no affidavit, no case. Okay? The elements of a contract, the prerequisites for a contract or agreement. One party must offer and enter into an agreement, and the other party must accept the terms of the offer. Does that sound like you? No, it doesn't, does it? Consideration. What is consideration? Something of value received or promised to convince a party to agree to the deal. Did you have that? No, probably not. Confirmation of correctness, verification. Confirmation of correctness, truth, and authenticity by affidavit, oath, or deposition. You have none of those. Okay? These people just write something down on a piece of paper and they start enforcing it. Proof of claim. Contractual capacity, competent parties. Both parties must be competent to enter into the agreement. Legality. The contract's purpose must be to accomplish some goal that is legal and not against public policy. Genuineness of assent, arguably part of the agreement. The apparent consent of both parties must be genuine. Consent and form. The agreement must be in whatever form, either written, under seal, oral, whatever the law requires. Okay? What are unilateral and bilateral contracts? Every contract involves at least two parties. Are they enforcing a contract that they have with you? Are they enforcing a contract where you are a party? Okay? Offerer, promiser, who makes the offer, and the offeree, to whom the offer is made. Did they offer you anything? Did they give you consideration? Hey man, we'd like to take half of your money and give it to the state, and then give your ex-wife 2/3 of that, and so just sign here, right? No, they didn't do that. Unilateral contract. A unilateral contract arises when an offer can be accepted only by the offeree's performance. Bilateral. Bilateral contract arises when a promise is given in exchange for a promise in return. What did they exchange with you? What did they give you? What did they compensate you for your labor? Expressed contract. A contract in which terms of the agreement are fully and explicitly stated orally or in writing. Did you get one of those? I didn't. An implied in fact contract, a contract formed in whole or in part by the conduct as opposed to the words of the parties. In order to establish an implied contract, the plaintiff must have furnished some service or property to the defendant. The plaintiff must have reasonably expected to be paid, and the defendant knew or should have known that a reasonable person in the plaintiff's shoes would have expected to be paid for the services or property rendered. So this basically is, you go over to your friend's house, hey dude, I'll mow your lawn for $10, and he says, okay. Okay, that's an implied contract. Quasi or implied. A fictional. What's fiction? It doesn't exist. It's fiction. That's Alice in Wonderland. That's Clown World contracts imposed on parties by a court in the interest of unfairness, injustice, fairness and justice, typically to prevent the unjust enrichment of one party at the expense of others. So we have formal and informal contracts. Formal contract is a contract that requires a special form or method of formation, okay, in order to be enforceable. That's what you're looking for. Where is the contract? Here's a contract under seal. This is where, like in Utah, you have commissioners that do the divorce, and then they drive over to the district court, and they get some stupid judge that's an idiot that's getting paid through incentive funds from child support to go ahead and sign their documents and try to make it quasi-legal. Okay, formalized writing and a special seal attached. That would be the stamp, court clerk, court seal, whatever that is. And then child support says, well, we're just enforcing the court order, because it's not a court order. It's not from a real court. Okay, that's how they get you. And I've talked to these people on the phone several times, and they all say the same goddamn thing every time. Well, we're just enforcing the contract. Well, that ain't my contract. Contract under seal, an acknowledgement by the court or person that he or she will perform. Well, do they have an acknowledgement from you? Do they have your signature on a piece of paper that says you have an obligation or pay a certain sum? Okay? Negotiable instrument, a check, note, draft, or certificate of deposit, each of which requires certain formalities. Letters of credit, we don't have to go into that. Informal contract, that does not require a specific form or method of formation in order to be valid. The vast majority of contracts are informal, which are without a seal, okay, which means without a judge, okay? You rent your house, or you bought your house, or you rent your apartment, or you work. None of that stuff is really a contract. You have an employee application, and then you have other stuff, but most are informal, okay? Hey, bro, let's go to the thing. I'll buy the tickets. You pay me back, okay? That's little stuff. Execution and validity of contracts. Executed contract. Executed contract, excuse me. A contract that has been completely performed by both or parties. By contract, an executory contract is a contract that has not been fully performed. Okay, so what is this? Executed, executory is a contract that's been completely performed. Okay, so that's you and him. Hey, dude, I'll mow your lawn for 20 bucks. Okay, you mow it, you go to the front door, you knock. He says, it looks great. Here's 20 bucks. Boom. Okay, that's done. Valid contract, a contract satisfying all the requisites discussed earlier: agreement, consideration, capacity, okay, assent, legal purpose, and form. By contrast, a void contract is a contract having no legal force or binding effect. In other words, it's a contract entered into for an illegal purpose. Why the hell was that in there? Okay, that was weird. Voidable contract is an otherwise valid contract that may be legally avoided, canceled, or annulled at the option of one of the parties. Hey, do you have the option to cancel this contract that you didn't sign up for? Now let's get into proof of claim. Your main defense against government greed and corruption. Once again, what does the government do? What do they manufacture? What do they produce? They produce nothing. Okay? The key to contract interpretation is to give the effect of the intent of the parties as expressed in their agreement. Intent is generally to be ascertained objectively by looking at the words used by the parties in the agreement, the actions of the parties pursuant to the agreement, and the circumstances surrounding the agreement as they would be interpreted by a reasonable person. Okay? So in other words, where's the contract? Did I get to consider your services? How about this? How about, what evidence do you have that I was not supporting my child before the divorce? You don't have any of that. What evidence do you have that I'm not going to support my child after the divorce? You don't have that. So why are you inserting the state into my life? Okay? And then stealing my money and then taking a fee. The plain meaning rule. When a contract is clear and unequivocal, a court will enforce it according to its plain terms. So this is what I'm dealing with, okay? The commissioner wrote up the divorce decree. He signed it off, and they're just enforcing the contract, okay? Well, I'm not in there. I'm the surety for that contract, but I'm not consenting and never did consent. Power 1, your first duty is to question authority, okay? This is your number one priority right here. If you do not challenge their authority, okay, their doctrine kicks in. That is, your first duty is to honorably, always stay in honor, accept the agent's presumption, okay, upon proof of claim. This is called conditional acceptance, okay? United States Supreme Court has ruled that it is your duty, your responsibility, and your obligation to determine the validity, authority of anyone representing themselves to be an officer of the government, okay? So how do you do it? How about you write this down on a piece of paper and send it in? I am required to initiate a direct challenge to the authority of anyone representing himself or herself to be a government officer or agent prior to the finality of any proceeding in order to avoid implications of de facto officer doctrine. When challenged, those posing as government officers are required to affirmatively, that's an affirmation, okay, that's an affidavit, prove whatever authority they are claiming. Additional authorities on the subject: public officers are merely agents of the public whose power and authority are defined and limited by law. Any act without the scope of the authority so defined does not bind the principal, that would be you, and all persons dealing with such agents are charged with knowledge of the extent of their authority. Okay? When the right to do a thing depends on legislative authority, and the legislature has failed to authorize it, how about that right there is talking about 42 USC, okay? Title 42, okay? Health and Human Services, Social Security Act, Title 42, look it up. It's not positive law. No amount of acquiescence or consent or approval of the doing of it by a ministerial, okay, a clerk, can create a right to do a thing which is not authorized and forbidden. Okay? Here's part 2. Your second duty is to challenge the agent and prove his claim under oath, under penalty of perjury. Government officers and debt collectors will never do this. Okay? Here's the Administrative Procedures Act. Except as provided, otherwise provided by statute, the proponent of the rule and order is the burden of proof. So show me. You are hereby ordered to provide me with proof of claim that I am the debtor, the obligor, the felon, the non-custodial, the pay rent, whatever the hell they say on their, on their paperwork, to whom the letter is addressed, made under penalty of perjury before a state notary, testifying that I am whatever you're calling me. Okay? To provide me with verification of proof of claim that, blah, 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 to provide me with the contract that obligates me to some kind of performance, okay? That's what you're looking for. And if they don't, then they have acquiesced and they have defaulted and they are in dishonor, and you can take that to court, and all your documents must be certified mail and witnessed with affidavits and proofs of certificate of mailing, and then you can send it in there and go boom in the courtroom and say, what about this? Prove your claim, bitch. You guys have a happy Mother's Day.